Y'all, we are on it today. Welcome back. Welcome back. Welcome back. So we're going to go over the FBI plea deal for the former police chief, Lacey. Before we get started, thank you guys so much for tuning in. Thank you guys so much for your support. As you come in, hit that damn like button. And as always, since it's been a minute since we've talked about Super Stupid and her little lackeys, we're here for this. Now, if you are new to the world of Tiffany Henyard, you know, this weird ass woman that got voted out in Dolton last year as mayor in Thornton Township in the state of Illinois, and then moved to Fulton County and is trying to run for Fulton County Commissioner at a point where now she has brought attention to her residency, because when she signed a lease, she was also sitting in the mayoral position in a whole nother state. And we have laws. Why do stupid things like this? I'm glad you all asked, because that's why I call her super stupid. She doesn't think about this dumb thing she does. She just does it. She doesn't think about the consequences of it. And believe it or not, you know, she's got following where they believe that she can do no wrong. And they don't ever challenge her on anything. Even though she's a grown-ass woman and she doesn't pay their bills. You can't make this up. So we're back at it again. We're going to go over the FBI plea deal of her former police chief of Dolton, Lacey, pillow top ass, who's got it coming. Now, mind you all, he's done a plea deal and everything a while back. Like, he was not going to play around with this. The police chief going to prison. Come on. Some of those people he helped put in there. But I want to jog some of you all's memories. And for those who don't know who he is at all, give you a little introduction. He's been corrupt since day one. Okay. And these people choose to be this way. And Tiffany Henyard cannot sit back and say, I didn't know my police chief and my right-hand man, Keith Freeman, were both corrupt. Who knew? All these people work around each other. Birds of a feather flock together. And if we believe that to be true as a statement, and with anyone else, why all of a sudden is Tiffany Henyard exempt from this? She knew what they were doing. And so the FBI plans to get that information out of them with these plea deals. They're going to have to cooperate. So we went over the one with Keith Freeman earlier today. And now we have Lacey. Pillow top ass. When y'all see him, you laugh, you see exactly what I'm talking about. So here's one of the videos here. I think earlier we put up a video with Nate the lawyer. He was actually talking about both Keith Freeman and Lacey. But here's one of the videos here. Just a little quick recap on the indictment when it first dropped. Let's get to this, y'all. Hit that like button. Thank you all so much. What's going on, Sonya Calhoun? How you doing? Jeff, how you doing, honey? How's it going? Shout out to my mods. How's it life out there on the ship? Yeah, salute to all the people serving our military. Juju back up in here. Francisca back up in here. I appreciate all of you all. Y'all have the best mods on YouTube. Thank you all so much. Noah up in here. How you doing, Noah? What's going on? Y'all hit that like button. Hit the phone when you can see it here. Let's go.
First, though, breaking news in the south suburbs. A federal indictment just announced against the former deputy police chief of Dolton. This is Lacey at a recent village board meeting. He's now charged with bankruptcy fraud. Lacey is accused of scheming to hide assets and income from creditors and trying to avoid paying a lawsuit settlement. He was fired as Dolton's deputy chief just last week. This comes as the village's finances are under investigation.
That was the investigation now when that first came out. All right. So let me pull up a video where this idiot tried to go to work after being fired. Oh, let me show you all where he was rehired, because she thought she was doing something.
We are following some breaking news out of suburban Dolton.
And this comes just days after the trustees terminated the deputy police chief. Now the mayor of the village, Tiffany Henyard, has appointed him to a new position. NBC5's Regina Waldrop has reaction on today's announcement.
Good evening. An illegal appointment. That's what the trustees I talked to are calling this. They say the news took them by surprise, and now they're talking to legal counsel to figure out their next steps. Now, it was last Monday that Deputy Dolton Police Chief Louis Lacey was put on administrative leave by the Dolton Village Board. Trustees say he returned to work the next day and was later fired for insubordination.
So why would she do that is the question. And she wants to say she didn't know he was this corrupt and this bad, and I didn't know he was trying to facilitate bankruptcy fraud and avoid paying creditors and judgments, and I had no idea. Why go to bat for these people? See, here's the questions that no one wants to ask Tiffany Henyard. Why the hell would you rehire this idiot? Why? Why was he worth you doing that? You know, more stupid ass decisions she made that no one wants to question. She had no reason to rehire him, especially when she found out he was indicted by the FBI. No reason to rehire him for something. And she was not supposed to do it the way she did it. She was supposed to get approval from the board. There are laws in place for a reason. Either you're going to follow them or you're not. The fact that she has come to Fulton County, the city of Atlanta, to try to circumvent the process on her residency goes to show she could care less about a law. She doesn't care about rules or regulations. And for her to go out her way to rehire this idiot, why? Why would you do that? You violated local ordinances to do this. Was it worth it? Super stupid. Was it worth it? You can't say that you didn't know he was a bad guy, he was corrupt. You could read, I hope. So you could have read the indictment and see for yourself what he got going on. Why stick your neck out for somebody like this? It was so stupid. You know, it's super stupid.
Then today, trustees say they got word that Mayor Tiffany Henyard has now appointed Lacey as police chief without trustees voting on this appointment, and they say Lacey has also not been sworn into the position. Now, Lacey was in court a short time ago. He was arraigned on federal bankruptcy fraud charges. It's alleged that he lied under oath in a scheme to hide assets and income from creditors to avoid paying more than $40,000.
See, she rehired him knowing that he had been indicted and arraigned on FBI charges, on felonies, criminal charges, an indictment from the FBI. She stuck her neck out to rehire him for what? It didn't stop him from making a plea deal. It's not going to stop the FBI if they decide to revoke it either. Let his ass not cooperate. Oh, we're going to go over his plea deal in a minute. But it didn't stop him from making a plea deal. So what was that supposed to do? So he's going to throw her ass underneath the bus to keep his ass from going to prison. Yeah, because he does not want to go. Neither does Keith Freeman. Funny how she sat here and broke a whole local ordinance and tried to override the board to rehire this man who had already been indicted and arraigned on charges brought forth by the FBI. And all for what? To get to the point where he's still making a plea deal and he's still going to throw her underneath the bus if it means maintaining his liberty and freedom. He gets in there and play in the FBI faces if he wants to. They will lock his ass up for the maximum prison time and hopefully put him in a prison cell with Debo and him. You know, everybody he's thrown in jail and mistreated. Yo, you'll have it coming, Louis Lacey. You dumbass. Potato Head will have it coming. But why do this? These are the questions that no one wants to ask her. Why would you do this? Is stupid. It was not worth it. And you rehired him. With all that he got going on. Within the course of what, 2-3 days? Indicted and arraigned on felony charges by the FBI. You rehired him and you didn't get the permission from the board. You failed to follow your own local ordinances. You're the mayor. Yeah, stuck on stupid on steroids.
In a lawsuit settlement.
Well, Mr. Lacey is absolutely not guilty of all 9 counts. I believe he's cooperating.
Yo.
And if you cooperate, you have to admit your guilt first.
And happening here tonight
Child.
in South Holland, a special meeting called by the Thornton Township Board of
Renee,
Trustees.
things how you doing?
They have a number of items on the agenda looking to curtail spending that they say is being done by Mayor Tiffany Henyard, who is also township supervisor. We should also mention that the township is now into its new fiscal year and still without a budget.
Are they related?
Reporting from South Holland, I'm Regina Waldrop, NBC 5 News.
Regina, thank you very much. And there are more money troubles tonight for the village of Dolton. Illinois Controller Susanna Mendoza has stopped what are called offset fund payments in the south suburb. She says.
So I'm going to just pause that there because I just wanted, for those who weren't familiar with Louis Lacey, for you all to know who he was. So let's get over to his 22-page plea agreement. Are y'all ready? Now, his plea agreement was filed back on November 21st of 2025. Keith Freeman's plea agreement was recently filed March 17th of 2026, about 3 weeks ago, almost a month ago. But Louis Lacey's plea agreement was filed last year, November 21st, right before Thanksgiving. So was it worth it, Tiffany Henyard, to sit here and to rehire someone who had been indicted by the FBI? And at the end of the day, he's going to rat you out. That's how that's going to go. Because thieves have no loyalty to each other at all, especially when they're narcissists. You can't make this up. So here we have the plea agreement. U.S. of A versus Louis A. Lacey, number 24 CR 377, Judge Thomas M. Durkin. This is in the U.S. District Court, Northern District of Illinois, Eastern Division. The plea agreement between the U.S. Attorney for the Northern District of Illinois, Andrew S. Boutros, and defendant Louis A. Lacey, and his attorney, Gal Paseski, is made pursuant to Rule 11 of the Federal Rules of Criminal Procedure and is governed in part by Rule 11C1A. As more fully set forth below, the parties to this agreement have agreed upon the following. Here are his charges that he's pled guilty to, because that's what you do in a plea agreement. You're pleading guilty, right? So, you can't, like we said earlier, you can't just change your mind because you decide to not cooperate. You try to lie to the FBI and they say, oh, you're going to jail. You're going to prison. And then you turn around and say, well, I'm revoking my plea agreement. Okay, yeah, no, you can't do that. Nope. So, the superseding indictment, because I knew it was going to be a superseding indictment. And if you guys check out the Super Tiffany Henyard playlist on my channel, in the Lady Luck Club, I have a whole playlist where I've gone over the actual indictment, and I said flat out, I expect there to be a superseding indictment. The superseding indictment means that they can have additional charges brought forth in the midst of an investigation, even after an initial indictment has been brought forth. So he was indicted, and then there were additional charges added. And then that superseding indictment basically is like an amendment where it takes precedence and priority over the initial indictment. Doesn't make sense? Hit the phone. Just so we can all be on one accord with when we see superseding. That's what this is referring to. Okay. The superseding indictment in this case charges defendant with devising a scheme to commit bankruptcy fraud in his 2019 and 2020 bankruptcy cases in violation of Title 18 U.S. Code Sections 157 through 3, counts 1 through 5, making false statements under penalty of perjury in his 2019-2020 cases in violation of Title 18 U.S. Code Section 1523, count 6 and 7, and making false statements under oath and pursuant to penalty of perjury in his 2019, because they lie like hell. It's the perjury for me. They lie under oath, y'all. Even if you're under oath on a stand, or if you provide an affidavit, a sworn affidavit, where you're making statements under the penalty of perjury, you can still be charged with perjury. Okay? Government does not like it when you lie to them. Just say you don't know if you don't know. But no, he provided blatant false statements that were proven false. And he did it under the penalty of perjury. Under oath and under the penalty of perjury, meaning it more than likely was in some sworn affidavit or some sworn document where you have to attest that the statements that you're providing are true to the best of your knowledge and ability under the penalty of perjury. So this is what lawyers do. I don't understand why he needs to go to prison either way, because he's an idiot. In violation of Title 18 U.S. Code Section 1623A, counts 8 and 9, and fraudulently concealing assets in his 2020 bankruptcy case. This is in violation of Title 18 U.S. Code Section 1521, count 10. So there are 10 counts that he is pleading guilty to. 10 counts. Keith Freeman had 2 counts. Louis Lacey has 10. You can't make this up. Oh, I just want to make sure all of you all are we all caught up right now. What's going on, Christopher Oliver? Glad they're all gone now. I was getting tired of that soap opera. All my criminals. Status Q is back with the status quo. I'm sorry, is back with us. I'm back. Permission to be aboard. Yes. Permission granted. Oh, S5, shout out to you. How you doing, honey? Shout out to my mom, y'all. Oh, man. This is something else. Y'all hit that like button. Hit that like button. All right. Let's keep going, because this is getting good. This is getting good. Only the queen of YouTube can read these boring-ass court documents and make it fun. Defendant has read the charges against him contained in the superseding indictment, and those charges have been fully explained to him by his attorney. Defendant fully understands the nature and elements of the crimes which he has been charged to which defendant is pleading guilty. By this plea agreement, defendant agrees to enter a voluntary plea of guilty to the following count of the superseding indictment. Count 1, which charges defendant with devising a scheme to defraud and for the purpose of executing and concealing the scheme and attempting to do so, filing a petition commencing a bankruptcy case under Title 11 of the U.S. Code in violation Title 18 U.S. Code Section 1571. They need to do an edit because they misspelled title. God. Hopefully the court clerk, somebody will catch this. Factual basis. Defendant will plead guilty because he is in fact guilty of the charge contained in count 1 of that superseding indictment. In pleading guilty, defendant admits the following facts and that those facts establish his guilt beyond a reasonable doubt and constitute relevant conduct pursuant to guidelines statute 1B1.3. On or about August 22nd, 2019 at Chicago in the Northern District of Illinois, Eastern Division, defendant Louis A. Lacey, also known as Louis Anthony Lacey, Sr., for the purpose of executing and concealing a scheme to defraud and attempting to do so, filed and caused to be filed a petition under Title 11 of the U.S. Code initiating a Chapter 13 bankruptcy case. This is in regarding Louis A. Lacey, number 19-23751, in the U.S. Bankruptcy Court for the Northern District of Illinois in violation of Title 18 U.S. Code Section 1571. And then they go through some background information here. He was employed as a police officer by the village of Dolton, was married, and resided at a residence on White Oaks Road in Matheson, Illinois, with his spouse, who was also employed. And they're saying this is because it's important to understand when you file in bankruptcy, you're telling the government, I'm broke as hell and I can't pay my bills. And then they're going to say, okay, well, tell me everything about your finances. That includes even if you're married and if your spouse is also working, who's bringing in any type of income or revenue. If you do have expenses, how the hell are they getting paid? So you got mortgage. Who's paying the mortgage? You should be homeless. Like, they go through everything. And if you lie, they'll hit you with a bankruptcy fraud charge in a minute. Because, see, what they don't want is for you to walk around not paying your bills. Can we get an amen to that? They don't want you walking around saying, I can't afford to live and pay my bills. There's people out here who are actually struggling. And if you get someone that is not struggling, like Keith Freeman and Louis Lacey, pillow top ass, him and Potato Head are lying to the court saying they can't afford to pay bills. And Potato Head was trying to do this specifically in an effort to avoid paying an actual court-ordered judgment against him. meaning the court had ordered him to pay a judgment. And he thought filing bankruptcy would prevent him from paying that judgment. That's not how bankruptcy laws work. You cannot file bankrupt in an effort to avoid paying a court-ordered judgment. Nope. So they told him, kick rocks, you're lying like hell, and we got you under oath lying, and lying on a sworn affidavit, documents filed with this bankruptcy case. So you lie like hell everywhere. So they're going to go through all your finances. So he lied and said he wasn't married when he was, trying to make it seem like he only had one income coming in the household. He did the same thing Keith Freeman did. Just stupid stuff all over the place. And you mean to tell me Tiffany Henyard did not know these morons are running around here lying like this, trying to avoid paying bills? You can't make this up. So they go through some of the background information regarding his BOA, I think his Bank of America accounts that he had, accounts that his spouse had on or about July 22nd, 2015. Case number 2015, L is as in Lacey, 007440 was filed in the Circuit Court of Cook County, Illinois, against Lacey, seeking a judgment in the amount of $88,800. The state case, as is known as in this agreement, on or about February 7, 2017, Lacey entered into a settlement in the state case in which he agreed to pay the plaintiff approximately $55,000, the settlement agreement. I personally would not have done that. If you're ordered to pay me $88,800, no, we're sticking with that. Because look what happens when you try to settle. So they settled down to $55,000, and then he tried to file bankrupt to avoid paying it all together. That's some grimy shit. You can't make this stuff up. He needs to go to jail. You can't make this up. So it was like, oh, okay, we're not gonna let you, we're not gonna force you to pay the $88,800. All right. We'll enter into a settlement and you pay $55,000. The other party agreed to it. And then he turns around and tries to declare bankruptcy. You know what? I ain't paying this at all. I'm just gonna say I'm bankrupt, not pay it. Because he doesn't know how laws work. You can't make this up. And Tiffany Henyard knew that he was doing all of this. Because I wouldn't put my neck out there to rehire someone who has been indicted by the FBI. The dumbest thing ever. Very stupid thing to do. It's stupid. She's stupid. Can't make this up. Oh, man. Dolton Mayor still free, crime pays. Yeah, she got it coming. That's the whole point of getting these two. Let's get the flunkies out the way. Child, on or about June 19, 2019, the plaintiff in the state case filed a motion to enforce that settlement agreement, alleging that Lacey was in default for failure to pay $43,000 of the amount due from the settlement agreement. So from $55,000, he had only paid $12,000. That left the balance of the $43,000. He didn't want to pay it. The circuit court set a status for the state case on August 2nd, 2019 to address the plaintiff's motion. Thereafter, beginning in or around August 2019 and continuing until in or around June 2020, at Chicago and Madison and Northern District of Illinois, Eastern Division, and elsewhere, Lacey devised and intended to devise a scheme to defraud and for the purpose of executing and concealing the scheme and attempting to do so, filed and caused to be filed a petition commencing a bankruptcy case under Title 11 of that U.S. Code, filed documents in a bankruptcy case under Title 11, and made materially false and fraudulent representations concerning and in relation to under Title 11 at the time, before and after filing that petition. He lied about all his income and finances. It was part of the scheme that for purposes of obtaining a stay of the state case in order to prevent the enforcement of that settlement agreement. Meaning, I'm going to file bankrupt. So when I go to court regarding the enforcement for that settlement, I can say that I'm going through bankruptcy proceedings and I cannot afford to pay this settlement. Where the hell he get the $12,000 from then to pay it? Y'all, this is crazy. So the fact that he had paid $12,000 towards the $55,000 settlement, it is very difficult to tell the judge, I can no longer afford to pay this. Because the first question is going to be, where did you get the 12 grand from? You paid $12,000 and you agreed to this. You signed documents to a court of law in a settlement agreement that you were going to pay $55,000 because it could have been $88,800. You paid 12 grand, 43,000 remains. Now all of a sudden you can't pay it all. Then why start paying? Why even agree to pay? You see how stupid this is? Why even do that? Just say, I can't afford to pay none of this. She's super stupid. And she rehired this idiot. You can't make this up, Child Sherry. I know this is unreal. This is ridiculous. I would have never even agreed to the settlement. I can't afford none of that. I don't know where y'all get $55,000 from. Hell no. I might have 500, and I have to put that aside in 2 checks. You gotta be kidding me. So that would be the first thing they have to establish. How did he come up with 12 grand? So trying to file, bankrupt to avoid paying a court order settlement that could have been much higher. That would have been much, much higher had they not agreed to settle with your dumb ass. What was wholly fraudulent. And you're doing it in their face. The FBI is like, yeah, keep playing in our face, and we'll show you exactly why you don't do that. Oh, man, you can't make this up. So Lacey attempted to and did defraud his creditors and the Chapter 13 trustee by making false and fraudulent statements in oral statements and documents. So he lied like hell. Those statements were designed. I'm not reading everything here, y'all. I'm just kind of skimming over. All right. So I'll just, y'all try to keep up with me. We're on page 4 right here. Those statements were designed and intended to falsely represent Lacey's actual financial circumstances, including by concealing the income of Lacey's non-filing spouse, who was then residing with Lacey, meaning they have a combined income coming into one household, and contributing to the payment of Lacey's expenses, which include living and mortgage expenses. So if she is bringing in a check and any of that money is contributing to a combined income, household income, where any of that money could be used towards his living expenses, meaning paying mortgage, rent, buying groceries, paying utilities, those things, then you're not sharing the burden of this expense by yourself. So you can't say, if my mortgage is $2,500, that I'm paying $2,500. She has a job too. The question will come down to how much of her income is also going towards that mortgage. Does that make sense? Hit the phone. Hit the phone. Well, make sure you all are with me. So that's what they consider when they're looking at the combined total income of that household. How much of this money is going towards all these living expenses? Because you're not paying it by yourself. And even if your arrangement is, I pay all the bills, you can't say that none of her money would aid in that. You can't say that. There's no way for you to prove that you did not use a dime of her money to pay towards your mortgage. How do you prove that? Because she could have given him cash. Who knows? So, since there's no definitive way to prove it, they have to consider realistically, there's a chance that some of her income can be going towards your living expenses. Does that make sense? Conceal bank accounts and true amount on deposit in these accounts, including BOA account 5121, from which Lacey and his non-filing spouse were paying their expenses with their combined income. See, this is what I just said. And that's how the courts consider finances, period. They always ask if you're married or if anyone is of age that is working and bringing any income into the household. They consider that to be a part of that total combined income for that household. So that's that. Concealed that Lacey's monthly payments under his proposed Chapter 13 plan of reorganization were calculated based on materially false information. So he lied about his income and told them, all my bills are being paid based on this X amount of dollars that I get per year. On August 22nd, 2019, Lacey filed and caused to be filed a bankruptcy petition in U.S. Bankruptcy Court for the Northern District of Illinois, thereby initiating Chapter 13 bankruptcy case captioned in regarding Louis A. Lacey, number 19-23751. And that's the 2019 Lacey bankruptcy case, as is known as through the pleading, which automatically stayed the state case, thereby preventing the enforcement of the settlement agreement. So, because he filed that, it automatically put a stay on the settlement, the $55,000 settlement case. So he was not forced to pay the money, but he lied like hell to avoid doing that. Well, that's some bum ass behavior. Louis Lacey is a bum. All right, he's a bum, and this woman rehired him illegally. No reason to do any of this stuff. You can't make this up. Oh, Jesus Christ. Sherry says his ex is the child of one of the most lucrative funeral home businesses in the state of Illinois. Are you kidding? Oh, child. Oh, hi, say, how you doing, honey? Artis, how you doing? What's going on? Shout out to my moms, y'all. I appreciate you all. You guys are awesome. Pretty sure they were together then. Oh, yeah, they were. I don't even have y'all seen any divorce documents on this? I don't know if he's divorced. I haven't seen anything showing that he's been divorced. So more than likely, they're probably still married, like legally married. Who knows? Maybe she left his ass because he got indicted. Like, I can't take the lies anymore. You shouldn't have taken them to begin with. Look how bad his lies are getting you caught up in this nonsense. This is so crazy. The same day Lacey filed and caused to be filed in the 2019 Lacey bankruptcy case, his schedules and a statement of financial affairs signed under the penalty of perjury. Those financial affidavits are legal documents that can be used in the court of law. And when you sign on those affidavits, you're making sworn statements under the penalty of perjury. Do not lie on those documents. It's no different than them saying, can you put your hand on the Bible, raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth? So help you God. It's the same thing, except it's all in writing. That's it. So he lied like hell on that. And then they got the schedules that he lied on, and the incomes he lied about, the falsely stated debts that he had. Because I'm not going to read all of this. I am going to drop the link so you guys can check this out and read in detail if you want. I will read this part here because, this is how bad he lied about his income. Lacey filed and caused to be filed a schedule 1 that was false and fraudulent, and that Lacey, well knowing that he was married, not separated, and that his non-filing spouse was residing with him, earning income and contributing to the payment of Lacey's expenses, did not disclose his non-filing spouse's employment, occupation, employer, and monthly income, and falsely represented that his combined monthly income was approximately, get this now, $4,995, when he knew that his monthly income was substantially in excess of $4,995, and that Lacey knew that he had calculated his monthly income without including his non-filing spouse's income. He told these people that he gets $5 shy of $5,000 a month. Why not add the extra $5? You say, I don't know. He said, I only get $4,995 a month, y'all. I'm sorry, what's the amount again? $4,995. Why you just can't say $5,000? And he did not even tell them about his spouse, who had a whole ass job, about her income at all. And if she was, you said she's the child of one of the most lucrative funeral home businesses in the state of Illinois, child, that means she has access to income as well. So let's just say if she needed to get $5,000, she could get it from her family. So they have financial support that they could draft too. Yeah, so he lied like hell about that. You can't make this up. Let's see here. Okay, here's another area where he lied about some money. The same day Lacey filed and caused to be filed a Schedule EF in the 2020 Lacey bankruptcy case. So they had a 2019 case and then a 2020 case. He lied back to back in 2 different bankruptcy cases, disclosing total unsecured debts of approximately $186,354, which Lacey sought to have discharged, including the approximately $43,000 owed to the plaintiff as part of that settlement agreement in that state case. So despite the fact that he came up with $12,000 to pay, he didn't want to pay the rest of the $43,000. And he lied to the court and told the court that that was a debt when it wasn't. It was a settlement agreement. Bankruptcy laws state that you cannot write off a court-ordered judgment. What you can do is negotiate a payment plan of some sort, unless you're just completely unemployed or you're disabled. It has to be something. But you cannot just say that he's going to, that the $43,000 you owe should just be written off as debt. Nope. That wasn't debt. That was a settlement. You lost. And a court and a judge ordered you to pay that amount. That's not like a light bill or anything. That's not how that works. So, hold on 1 second, you all. Hold on one second. Mama duty. Hold on 1 second. All right, y'all. Sorry about that. Okay, cool. Let's move on. So, on or about June 24, 2020, Lacey calls person A to apply for an advance on Lacey's behalf through the economic injury disaster loan. Y'all, that's part of that PPP loan. The same thing that Keith Freeman took advantage of and then lied about and did not report on his income tax. You get a PP loan from the federal government and then you don't tell the federal government on your income taxes that they gave you this money, but they know they did. So he didn't report it, I'm sure. So because of that person had to apply because he didn't want to pay the judgment. That person had to apply for the PPP loan, which provided loan assistance, including advances of up to $10,000 for businesses with 500 or fewer employees and other eligible entities. So they had to go get a loan. He didn't want to pay them any money. The EDIL advance was designed to provide emergency economic relief to businesses that were experiencing a temporary loss of revenue as a result of the COVID-19 pandemic. At Lacey's direction, person A applied for that EIDL advance on behalf of Lacey on the basis of Lacey's operation of a purported business and requested that the proceeds be deposited into one of Lacey's accounts. Oh, my dear Lord. It wasn't the person from the settlement. He went and actually asked someone to apply for the loan for him. God almighty. You got to be more careful. Jesus, take the wheel. Y'all. Okay, let me rewind because I misunderstood this. I thought that the person that he owed the money to did it. Nope. He asked someone else to go out and apply for the PPP loan for him. Can y'all, but boy, this is something else. Oh, dear Lord. Let me read this again, y'all. We got to read it again because I don't want y'all to miss this. Tiffany Henyard rehired this idiot after he was indicted. Indicted and arraigned. And she illegally rehired him. And she didn't know all this shit was in the indictment. You can't tell me that You can't tell me that because I hope she knows how to read. She doesn't care about laws, but hopefully she knows how to read words. This is crazy. Who's person A? Your Honor, can you tell us who person A is? Because we need to know who person A is. Who was it? Keith Freeman? If it was Keith Freeman, boy, it's gonna be something else. June 24, 2020, Lacey told person A to apply for an advance on Lacey's behalf through the EIDL program. And hold on, let's go down. Let's go down. At Lacey's direction, person A applied for the EIDL advance on behalf of Lacey on the basis of Lacey's operation of a purported business. What business? And requested that the proceeds be deposited into one of Lacey's accounts at Chase Bank. God. Oh, this is so good. Y'all, this is so good. Hey, Critical Smoke, how you doing, honey? If Muff said, I'm listening from the bushes cooking. Chop. Y'all. Oh, my dear Lord. S5 said the PPP loans. Oh, my God. So many people took advantage of those during COVID. Exactly. Seeing this last between her and her two daughters, they got 3 each or something for fake companies. See, y'all, this is so crazy. Yeah, just rudimentary reading skills or lacking comprehension. She won't read laws, rules, policies, emails, documents. Y'all, this idiot has someone go out and do an application for the PPP loan during COVID under some purported business. Who knows what that is? At least Keith Freeman LLC, like we were able to look that up in the previous live we did earlier on his. And it goes under that Duda's novelty. We were actually able to pull up that LLC and the registration for it. It still, to me, seems like a shell LLC he's using to funnel money through. And that's just how my opinion is. And based on the fact that I didn't see an online store. So in my opinion, it seems like a shell LLC that he's using to push money through. This here, where's his LLC? What purported business? He worked as the chief of police for Dolton. What business? Oh my God. And requested that the proceeds be deposited into his account, not the person A account, not the person he told to go get the loan. No, he wanted them to get the loan on the basis of Lacey's operation of a purported business. They don't even name it. And then requested that the proceeds be deposited into his Chase Bank account. Which account Lacey failed to disclose in his 2019 and 2020 bankruptcy cases. Lacey, however, did not own the business. There you go. Oh, that thunkhead didn't even own a business. Oh, Lacey. Listen here, you peanut head. You go to prison, boy, they're going to whoop your ass. Oh, they're going to be so mad. Why you in here? I lied like hell to the government. Told them I made $4,995 a month, not $5,000. And lied to them about having a business. PPP, loan fraud. I can just keep going. Oh, this is ridiculous. He didn't even have a business. So God knows what they put down on the documents for his so-called business for that PPP loan. Who knows? He could have put down ABCD Dog Company, and that would have been it. On June 25th, 2020. Oh, my God. Lacey calls the SBA, and that's the Small Business Administration, to deposit a $10,000 EIDL advancement into Chase account number 6891. Lacey subsequently transferred approximately $3,500 of that $10,000 to his daughter and approximately $2,500 of that $10,000 to person A. So he paid them $2,500 to do a fraudulent application on a business he did not own to get $10,000 for a PPP loan on a fake business. And he don't think he should go to prison. Dear Lord. But then when he gets fired, he still shows up to work the next day like he runs some. And Tiffany Henyard rehired his dumb ass. Y'all, this is priceless. Oh my goodness gracious. Oh, Lord have mercy. Lacey did not disclose to his bankruptcy attorney, the Chapter 13 trustee, the bankruptcy court, or his creditors the application for or receipt of $10,000. Nor did he tell them anything beyond that. He didn't tell them that he transferred any money and none of that. He doesn't have a business, none of that stuff. Foregoing facts are set forth solely to assist the court in determining whether a factual basis exists for defendant's plea of guilty and are not intended to be a complete or comprehensive statement of all the facts within defendant's personal knowledge regarding the charged crimes and related conduct. Maximum statutory penalties. This is the fun part for me. Defendant understands that the charge to which he is pleading guilty carries the following statutory penalties. Maximum sentence of 5 years imprisonment. This offense also carries a maximum fine of $250,000. Defendant further understands that the judge may also impose a term of supervised release of not more than 3 years. Pursuant to Title 18 U.S. Code Section 3013, defendant will be assessed $100 on the charge to which he has pled guilty, in addition to any other penalty imposed. Then they go over the sentencing guidelines, calculations, and determining, based on the amount that he has defrauded, the level of each offense, and the appropriate punishment based on the charges. Does that make sense? I'm not going to read all of that because this is a lot, and it's very boring. I'm going to go down and see if he's had any prior criminal history. Oh, because they do have it in these plea agreements. Let's see here. They're using the sentencing guidelines recently updated from November 1, 2025. So this was filed November 21st. So they had just updated the sentencing guidelines 20 days before they filed this plea agreement. They considered the base offense level at a level 6. Let's see. It also determines how many victims are involved. I think he had 10 counts. Oh, good grief. Trying to go to, and like I said, I don't want to read this whole thing because it's just a lot of fluff. Just kind of going over guideline statutes. Okay, criminal history category. Let's see here. With regard to determining defendant's criminal history points and criminal history category based on the facts now known to the government, defendant's criminal history points equal 0, and defendant's criminal history category is 1. All right. Let's see. Anticipated. So he hasn't had any other charges. Okay, I just want to make sure I had that. So that was it. Keith Freeman had a charge of theft, which it seems like it was a misdemeanor on his plea agreement that was noted. Oh. All right, let's go down to corporation. Defendant agrees he will fully and truthfully cooperate in any matter in which he is called upon to cooperate by a representative of the U.S. Attorney's Office for the Northern District of Illinois. This corporation shall include providing complete and truthful information in any investigation and pretrial preparation. The same thing with Keith Freeman. Get in there and play in their face if you want to when it comes to Tiffany Henyard. They will revoke this whole thing and lock your ass up for the maximum imprisonment time of 5 years. Judges also have discretion. So the judge could easily not accept this plea agreement or could alter it and say, The maximum imprisonment time is 5 years. He's going to serve 2 years and then 3 out on supervised probation for 3. The judge could do that. In this situation, I hope he does. Well, him and Keith Freeman need to share a cell together. You can't make this up. Who knew that their crimes would be so similar? It's like they both graduated from the school of the hard knocks. Bankruptcy fraud 101. They did the same dumb thing. The only difference is Louis Lacey did not have a business. Keith Freeman had an LLC. He did all his BS under. So, that's what it comes down to. But they both perpetuated PPP loan fraud. Both of them got PPP loans. Keith Freeman got more, but he had a whole LLC too. Louis Lacey got 10 grand, but he didn't have a business at all. I mean, he just flat out lied. God, this is so ridiculous. And Keith Freeman had a history of theft. Man, you can't make this stuff up. So he asked to cooperate. If they want him to come in and give information on any investigation regarding anyone else, he has to do that. Or else they will go back to the court, to the judge, and say, this idiot is not cooperating. He thinks that we're for play. We're asking that this plea agreement be rendered null and void. That's it. He's not cooperating, so we're not doing it. So that's part of this plea agreement. Full, truthful, willful cooperation in any investigation and pretrial preparation, and complete and truthful testimony. He might be summoned to testify. Super stupid. Keith Freeman and Louis Lacey could be summoned to testify against you. And they wouldn't even have to be summoned. They would have to be told, hey, we need y'all to come to court. This part of y'all plea agreement, y'all got to come to court. We should not have to summon you. And they have to go in and do it. Or they risk going to prison. Keith Freeman's looking at a maximum of 8 years. Louis Lacey is looking at a maximum of 5 so far. But they would have to go, they would either go testify or they go to prison and pay the fines and all that stuff. Oh, this is so funny. So they have to come in and give truthful testimony in any criminal, civil, or administrative proceeding. Defendant agrees to the postponement of his sentencing until after the conclusion of his cooperation. So let's say there is an investigation going on. And so far, Tiffany Henyard has not been indicted, but let's say she is indicted and there's a trial scheduled. They can be told to come in and testify. Their sentencing will not occur until all of that has come to a conclusion, because they want to guarantee that you're going to come in and cooperate. Or at any given time throughout this process, they're going to ask the court to render this plea agreement null and void. Yep, they sure will. So it would be in their best interest to not piss them off. Why would Tiffany Henyard be worth any of that? I don't know. But they want to sit here and try to play games and go to prison for her. They will go to prison for her. So they got to cooperate. Y'all, this is something else. Oh, Louis Lacey, you dumbass. Agreements relating to sentencing. At the time of sentencing, the government shall make known to the sentencing judge the extent of defendant's cooperation. Here it is. Because they're going to tell the court if you've cooperated fully. If not, nope. We're asking that this plea agreement be rendered null and void. If the government determines that defendant has continued to provide full and truthful cooperation as required by this agreement, then the government shall move the court pursuant to guidelines statute 5K 1.1 to depart downward from the low end of the applicable guideline range in an amount to be determined by the government at the time of sentencing. Defendant shall be free to recommend any sentence. If the government does not move the court pursuant to guideline statute 5K 1.1 to depart from the applicable guideline range as set forth above, the preceding paragraph of this agreement will be inoperative both parties shall be free to recommend any sentence, and the court shall impose a sentence, taking into consideration the factors set forth in 18 U.S.C. Statute 3553A, as well as the sentencing guidelines, without any downward departure for cooperation pursuant to Statute 5K 1.1. Defendant may not withdraw his plea of guilty because the government has failed to make a motion pursuant to guidelines Statute 5K 1.1. So if the FBI does not file a motion to say, this person cooperated with us, here's what we're asking you to do in exchange for it, blah, 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 and get that signed in an order, he can't go in and say, I'm going to retract my plea agreement and this guilty plea because you all didn't tell the judge to take it easy on me. They're going to say, boy, if you don't kick rocks, barefoot. Oh, this is too good. Who child? What's going on, Angela? How you doing, honey? Shout out to you. Sherry says she will be because she was so in your face with her shenanigans. Folks think she should be in custody by now. Investigations take time. They do. And here's the best part about these plea agreements is that the corporation, they know if you sitting around BSing with them. Because they know if you don't cooperate, they're going to retract it. And then more than likely, you'll get the maximum time because now you've pissed off the government and the court and you've wasted their time. They're not going to let you do that. So the best thing for them to do is cooperate if they want to stay out of prison. Otherwise, they're going to prison. And as you all saw, there was only one count in here in this plea agreement that he's pleading guilty to. But he was indicted on 10 counts. So if y'all see the charges in this case, it ends with 10 counts. Count 10. Y'all see that? And this is on page 2. What he's pleading guilty to is count 1. Does that make sense? So if he does not cooperate with this, he could face being charged with 10 counts, which would come with a lot more prison time. Let's say count 1, maximum time is 5 years. Let's assume all the other counts, all the other 9 counts have the same amount of time. You're looking at 10 counts times 5 years. How long is that? 50? And that's maximum time. So he could be looking at 50 good years. And I'm not saying that's the thing, but I'm just being hypothetical. If each count has a maximum prison time of 5 years and there are 10 counts, that's 50. Let's say reasonably, all 10 counts would consecutively have a maximum time consecutively of 25 years. He still would go to prison for 25 years. You think he's trying to do that? He's not trying to go to prison at all. He doesn't even want to go for a week, let alone 5 years. Or 3 years. He doesn't even want to be in there for 6 months. Hence why he's doing this plea agreement. He doesn't want to go to prison. They're not trying to go to prison for him. And this is part of that investigatory process that does take time. Now they have 2 people with these plea agreements that they should not even have to subpoena or summon to come in and testify. All they have to do is notify them and let them know, we need you to provide this discovery, this information, and come in and testify. They can't tell the FBI, you're going to have to subpoena me. Nope, not under this plea agreement. Get your dumb ass up and go wherever they need you to go and go and testify. This is keeping you out of prison. And they know it. And I'm sure their attorneys are reminding them of that every single time they get a call from the FBI. This is keeping you out of prison, so you might want to do it. You want to go to prison or no? Because we fought for this plea agreement, and this is a pretty good plea agreement. 1 count he's pleading guilty to when he was charged with 10. Jabu. So Louis Lacey, getting over a little easy here. But they don't give you a plea agreement if they don't feel that you have plea agreement worthy information to provide. If you're not going to be a credible witness and to be able to provide evidence that could be used, that will be material to their investigation on her, they wouldn't even waste time with the plea agreement to begin with. Because it's nothing for the FBI to say, we'll go to trial. The case against you will be overwhelming. You'll go to prison for many, many years and we'll sleep peacefully. It won't bother us at all. It's nothing for them to say, well, you don't have to do this and that. We'll go to trial and then we'll go from there. It doesn't hurt their feelings one way or the other. So you choosing to agree to do a plea agreement, it really helps them. But it's no love lost if you don't. Because the end goal for them is the conviction at what, 99.99%. So that's the end goal. Either way, they're going to win their case. So this is at the behest. It behooves the defendant to do the right thing. So this is what we are. Y'all, this is something else. Let's see here. So we got, after sentence has been imposed, I want to make sure I'm trying to see where I'm at. Okay, yeah. Defendant further acknowledges that if the court does not accept the sentencing recommendation of the parties, defendant will have no right to withdraw his guilty plea. There it is. So even if the court doesn't accept it, because the judge is not a party to this, the judge doesn't have to accept it. The judge could amend it. The judge could alter it. The judge can impose a sentence beyond what's in this plea, the actual plea agreement. But he can't withdraw his guilty plea because of that. So this is part of what he understands and agrees to in this plea agreement. Defendant agrees to pay the special assessment of $100 at the time of the sentencing with the cashier's check or money order payable to the clerk of the U.S. District Court. After sentence has been imposed on the count to which defendant pleads guilty as agreed herein, the government will move to dismiss the remaining counts of the superseding indictment as well as the indictment as to defendant. Y'all see that? So he's only pleading guilty to one count. Mess up if you want to, Lacey. Potato head. They'll come at you with all 10 counts. And then they'll sentence you accordingly on that. So now, he better cooperate. It will behoove him. Acknowledgments and waivers regarding plea of guilty, nature of agreement. This agreement is entirely voluntary and represents the entire agreement between the U.S. attorney and defendant regarding the defendant's criminal liability in case 24 CR 377. This agreement concerns criminal liability only. Let's see here. I'm going to read down some. Waiver of rights. Defendant understands that by pleading guilty, he surrenders certain rights, including the following: trial rights. Defendant has the right to persist in a plea of not guilty to the charges against him, and if he does, he will have the right to a public and speedy trial. But he's waiving that right. So that's what happens with these plea agreements. You're waiving your right to a trial. You're waiving your right to be indicted. You're also waiving your right to an appeal. So I'm going to just highlight those major points there. Y'all see waiver of appellate and collateral rights. So he can't go and appeal this once sentencing has been imposed. He can't go back and appeal. Because he has entered an agreement and the court accepted the agreement at the time of sentencing, he cannot go back and appeal it. So he waives that right to appeal. He waived his right to a jury trial. If he felt he would win, he would have just went to jury trial. And I thought that's what he was going to do. You know, he was being real bold once upon a time. Potato Head was trying to be real bold. He was like, no, I'm never going to testify. They just want me to testify against Tiffany Henyard. Of course they do. You kidding? Isn't that the goal? See, here's the thing. The FBI is using the same tactics that they've used since the beginning of the inception of the FBI. since the 30s, 40s. There's nothing that they're doing that's any different than what they've already done for the last 7 good decades. The thing is, it still works. So when we saw the video news reporting of the attorney talking about, oh, well, they just get you on this so that you can testify against someone else. But it still works. That's why they still do it. And as you all can see, they gave him a sweet plea agreement because they wanted to be worthwhile. Going from 10 counts to only pleading guilty to 1 count, that's a sweet deal. And if he can walk away and not go to prison, child boo. The most you have to pay so far is $100. And that's if the judge accepts it, right? So if the judge accepts and agrees to it, then this will be the most you have to, endure. Some supervised probation, paying $100, and maybe paying some other fees and stuff. And you still got to pay that judgment. But you don't have to worry about going to prison. Oh, you got to come in and testify against Tiffany Henyard. Oh, okay, cool. Because that's the whole goal. But see, that tactic still works. That's why they still do it. And it's not illegal. It's just what's illegal is him having someone apply for a PPP loan for 10 grand and it goes to a bank account with his name on it. And he knows damn well he didn't have a business. Oh my God. It's so blatantly stupid. So he waives his right to a trial, waives his right to an appeal. Let's see here. This is about the pre-sentence investigation, post-sentence supervision. So everything that happens, it'll go over to the probation after he's sentenced. He agrees and acknowledges that. He has to make the court known that if something is not correct, especially when it comes to the sentencing, that will be spearheaded by his probation officer, he has to inform the court of that. So let's see, for the purposes of monitoring defendant's compliance with his obligations to pay a fine during any term of supervised release or probation to which defendant is sentenced, defendant further consents to the disclosure by the IRS to the probation office and the U.S. Attorney's Office of defendant's individual income tax returns filed subsequent to defendant's sentencing to and including the final year of any period of supervised release or probation to which defendant is sentenced. Defendant also agrees that a certified copy of this agreement shall be sufficient evidence of defendant's request to the IRS to disclose the returns and return information as provided for in Title 26, U.S. Code Section 6103B. Other terms, defendant agrees to cooperate with the United States Attorney's Office in collecting any ordered fine for which defendant is liable, including providing financial statements and supporting records as requested by the U.S. Attorney's Office. He cannot tell these people, go get a court order. Yeah, okay. Part of your agreement is you give up any information they're asking for. And they should not require a summons or a subpoena to do it. You have to remain fully cooperative and compliant with this plea agreement. Defendant understands that if convicted, a defendant who is not a U.S. citizen may be removed from the United States, denied citizenship, and denied admission to the United States in the future. Is he illegal? We will have your ass deported. You can't make this up. In conclusion, defendant understands that this agreement will be filed with the court and will become a matter of public record and may be disclosed to any person. That's why we're reading it. Defendant understands that his compliance with each part of this agreement extends throughout the period of his sentence, and failure to abide by any term of the agreement is a violation of the agreement. Defendant further understands that in the event he violates this agreement, the government, at its option, may move to vacate the agreement. So vacate the agreement means it never existed. You're going to prison. We can have a trial and everything else, but you playing around. This will be rendered null and void. Oh, man. Pillow top, potato head. You better cooperate. They can have this whole thing vacated. Oh, dear Lord. They will move to vacate the agreement, rendering it null and void, and thereafter prosecute defendant not subject to any of the limits set forth in this agreement, or may move to sentence defendant or require defendant specific performance of this agreement. Defendant understands and agrees that in the event that the court permits defendant to withdraw from this agreement, or defendant breaches any of its terms, and the government elects to void the agreement and prosecute defendant, any prosecutions that are not time barred by the applicable statute of limitations on the date of the signing of this agreement may be commenced against defendant in accordance with this paragraph, notwithstanding the expiration of the statute of limitations between the signing of this agreement and the commencement of such prosecutions. They will take his ass back to court. They'll go for the full maximum penalty on all 10 counts. His ass will go to prison and have to pay many, many fines. Play around with this, Louis Lacey, if you want to. Oh, I know it. God have mercy. Ooh, child. Yeah, he tried the tax evasion thing. He didn't report all of his income on his taxes, but this is more so bankruptcy fraud and PPP loan fraud too. Y'all, this is something else. He definitely went kicking and screaming. Keith was like, Tiffany is going down before I do, or if I do. His greed has betrayed him. What's going on, Stork? How you doing, honey? He should still get prison time, in my opinion. Me too. I think he should go. He got 10 counts. I think he should definitely get some time in prison. Even with a 5-year maximum sentence, he should definitely go to prison for at least 3 of that. I think that would be more than reasonable for the judge to still look at this and look at, the counts and how he tried to abuse the court behind a bankruptcy to avoid paying an enforcement for a settlement agreement that the other party did not have to even agree to. They could have just said, nope, he needs to pay the full $88,800, pay the full judgment. We're not playing. But they agreed to a settlement, and then he tried to get out of it by hiding behind bankruptcy laws that don't apply to judgments. Court order judgments don't apply. But he tried it, and it's disgusting. So, considering the number of counts and the egregious nature of how he tried to defraud and manipulate the court, I think his ass should go at least 3 out of the 5 years. For sure. Now, if he pisses them off and they vacate this agreement, they're going to get him on all 10 counts. So he'll go either way, and it's going to be for a very long time. It'll definitely be for more than 5 years if they end up doing it. He can keep kicking and screaming. Potato Head, I'm going to tell you right now, they don't care that you are a former police chief. Now, those prison inmates might care, but the courts will not. They don't care now, and they will not care if they have to vacate this plea agreement. Your ass is grass. Oh, man. How you doing? What's going on, Camille? What's happening? Oh, my good God. Y'all, I've got to get clued up about this Tiffany Henyard bit. Yeah, ooh, child. How you doing, honey? Happy Sunday to you. Y'all make sure y'all hitting that like button. I know that for sure. Let's see here. Should the judge refuse to accept defendant's plea of guilty, this agreement shall become null and void, and neither party will be bound to it. Because the judge is not bound to this. They're the judge. Defendant and his attorney acknowledge that no threats, promises, or representations have been made, nor agreements reached, other than those set forth in this agreement to cause defendant to plead guilty. He can't say, I was coerced and forced. They put a gun in my head. Hell no. Get your ass on. Defendant acknowledges that he has read this agreement and carefully reviewed each provision with his attorney. Defendant further acknowledges that he understands and voluntarily accepts each and every term and condition of this agreement. Agreed this date, November 21st, 2025. Signed by Sarah E. Stryker on behalf of Andrew Botros, U.S. Attorney, Louis Lacey, defendant, Jason A. Julian, Haley Alt, Assistant U.S. Attorney, and Gal Pesetsky, attorney for defendant. Gal, is that a dude or a female? Is that a man or woman? I thought I saw a man. His name is Gal Paseski. Y'all, that's it. That is the end of this. Y'all, he agreed to this last year, November. All right. So what happens now is the sentencing will not occur until they have concluded that he is no longer of use. They don't need him any further to do something else, right? They will, if they're conducting this investigation with super stupid, what they would do is continue on with that. As he is needed, him and Keith Freeman, to come in and testify or provide evidence or documentation of any sort, they are required to cooperate fully. Okay. And if there's a hearing, if she's indicted and they have a hearing and she gets a trial and blah, 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 then they will have to come in and testify because they work too closely with her. One, to not come in and testify. And two, there's a lot of information they might be able to get their hands on that she probably will not ever want to give up. And I believe Keith Freeman gave them a lot of stuff while he was so-called trying to play around with this whole plea agreement. I said he was going to, both of them were going to flip. I said that. When they were indicted, both of them, the first thing I said is they're going to flip because they don't want to go to prison. FBI is not going to play with their ass, and they're not going to be able to beat the case. You're talking about bankruptcy fraud charges. It's too much documentation to show proof that you intentionally, knowingly, and willfully defrauded the court and tried to devise a scheme to get over on bankruptcy court to avoid paying your debts and creditors and all that. And in this fool situation, a whole settlement. I don't think any judge is going to appreciate that at all. They're going to look at this and be like, wait a minute. He was about to go through an enforcement agreement, a proceeding rather, and he tried to file bankrupt. Hell no. It's like a slap in the face. It's like, you know what? I don't care if a judge is trying to order me to pay this judgment. I'm just going to file bankrupt and they can kick rocks. That's not how that works. Laws don't cover that. You can't make this out. He tried it. Oh, man, he tried it. So, y'all, this is Louis Lacey. You know, he went in stomping around thinking that he was I'm never going to snitch. I have her back to November 21st, 2025. He signed this plea agreement. And Keith Freeman signed his on March 17th of this year, 2026. So we went over there in the Super Live. Make sure you guys go check that out. This has been a lot of fun. I love reading these court documents. And they have to agree. They have to cooperate. They have to do exactly what the investigators, the U.S. Attorney's Office is expecting them to do. And if not, this whole thing can be vacated. And the judge will toss it out. And that will be the end of that. And then they'll end up having to go through a trial and all that good stuff. And they'll end up facing the maximum time for wasting the FBI's time. You know, just because they're going to get that conviction. And that is their goal. So, good luck to Potato Head. You don't belong in prison, but whatever. Or you do, rather. But you don't want to go. So, you better do what you need to do to stay out of it. If the judge sends you there, it'll be better than you going through a full trial with 10 counts of this nonsense. So you're still getting off easy. Can't make this up, man. Can't make this up. I would have never been able to pull these shit stunts like this. And this is the person that Tiffany Henyard tried to rehire without the board consent. Why? There are others. She couldn't get somebody else. Can't make this up. Thank y'all so much. Y'all hit that like button. And we'll be back at it. It's been crazy for the last week and a half, 2 weeks, but I am so happy to have you guys hanging out with me, and thank you all so much for the support. I guess we'll go live and check out Candice later on with her Lord. She said something about Trump being gay, whatever. We're gonna check that out. Since so many of you said yes, let's watch it, so we'll have a viewing on that this evening. So you guys tune into that if you can. If not, I will see you all in the next one. Until then, Lady Luck Club out. Deuces.